Hey, everybody, and welcome to another episode of the Canadian Immigration Pros podcast. I am your host, Josh Schachnow, Canadian immigration lawyer and CEO here at Visto.ai. Very excited to be joined today by Alexandra Callinan. Alexandra, thank you very much for coming on the show today.
Awesome. Thanks for having me. I'm excited to be here.
Yeah, likewise. I mean, we were just talking off air. We had an express entry draw today, which we're going to get into the details on. Not
Yeah.
just the draw today, but the, in my opinion, underwhelming draws that we've seen so far. TR, transitioning TR to PR. So lots to talk about. Before we jump in, can you give a quick introduction? Tell everybody a little bit more about yourself.
Yeah, of course. So you're right. My name's Alexandra, although Alex is totally fine for the rest of the podcast. I'm a Canadian immigration lawyer. I was called to the bar in 2019, and since then I've been practicing exclusively in the area of corporate immigration with focus on economic applications for work permits and permanent residence. Before I became a lawyer, I worked for IRCC as a public servant. So that was from 2010 to 2014-ish. And during that time, I was processing and rendering decisions on study permits, work permits, visitor records. I did a brief stint there in refugee resettlement and then ended my career as a public servant at the case management branch. So I've had the opportunity to see immigration from both sides of things, so to speak. And now I work with clients, employers, and applicants to help facilitate applications for temporary residence and permanent residence in our economic classes.
Very interesting. So we'll get a good perspective from, both sides of the plate, as they say, as the lawyer representing clients, and maybe I don't know how much processes change, right, in terms of like how IRCC processes applications, but it'll be certainly interesting to kind of pick your brain there. Now, maybe what we'll do is we'll start off with PR, more specifically express entry. We're recording this on January the 31st, but this episode has probably gone live a few weeks later. So I want to give that caveat right away. But so far, Alexandra, we've seen 3 express entry draws. They've all been fewer than 1,600 people per draw, and they've all been general.
Yeah.
What are your thoughts on that? I mean, they were getting us all riled up about these industry-specific draws that they were doing a lot of in the second half of 2023. Now apparently it's gone. Like, what are your thoughts? What are you seeing on the express entry side?
Yeah, I mean, it's quite timely that we're chatting today. Of course, there was the draw today at 541, which is a 1 point reduction from the second draw, which was 542, the first draw of the year, 546. So we're seeing this continuation of the trend where these general draws are just astronomically high in terms of the points that you're going to need, which is making it very, very difficult for people who aren't, in the category-based selection criteria, which they haven't even drawn on this year, to really be in a strong place to be competitive in express entry. So I think we're seeing kind of a closing of the gates, so to speak, for skilled workers in particular in a way that we haven't seen, at least for me in recent memory. The conversation around unskilled workers and their ability to access permanent residence in Canada is one conversation, but traditionally speaking, I would have been much more confident, 2019, 2020, even to talk to people about, viability under express entry. Now, this year with these draws, my conversations with clients and consultations are a little bit more bleak.
Right. Do you have any idea why, or like what are you telling these clients? Cuz like it's one thing, the second half of 2023 I found interesting because they were still inviting a decent amount of people to apply every 2 weeks,
Yeah.
and they were mixing in a half decent amount of industry specific draws. And now it's been 1 full month into the year. We've had no industry specific draws. And the biggest draw they've done is for 1,510 people. So, like, I don't know. Like, do you know something I don't? Or are they just slow to start the year? Or because of all this study permit drama, maybe they're like putting the brakes on PR? Like, do you have any guesses
Yeah.
or any ideas?
Yeah, I mean, in terms of, true knowledge, I don't know anything you don't, but yeah, I think it's impossible to uncouple this from all of this, study permit drama, so to speak, and concerns about immigration levels and housing and the economy and unemployment and all of those kind of complicated topics that get put together when we're talking about immigration. So I don't know the logic behind pushing these category-based selection draws as heavily as they did and being really amped up about them in 2023, doing some of the STEM draws. I mean, the points were still high, to be fair, for even some of these category-based selections, staying in the 470s, 480s outside of, the French draws and transport, agriculture, and trades. But to abandon those entirely in the first month of the year sets a pretty dire tone for the rest of the year. And so the conversations that I'm having with my clients are becoming increasingly around what type of support can you get from your employer, if any? Are you able or willing to learn French at all? It's these really kind of very different conversations about what is actually needed to become a permanent resident through these economic streams in Canada now. And it's this real shift towards needing employer support, which, has its own kind of consequences in the labor market, right? Where we see kind of concerns about LMIA fraud. I know you did a podcast episode on that a few episodes ago, but we've created these conditions now where temporary foreign workers really do need much more hands-on support from employers in order to stay. And I think that puts them in quite a vulnerable position a lot of the time.
Yeah, and I definitely want to pick your brain on some of those other options, but my confusion is like, okay, I guess there's some drama from the study permit side, but that doesn't change the fact that we have a quota, or a target, I should say,
Yeah.
for PR, right?
Yeah.
Like the 500,000 PRs they want to approve per year, as far as I know, hasn't changed, right? So shouldn't, if we're following that logic, not that IRCC always follows, the logic, but shouldn't express entry be unaffected unless they come out and announce, hey, we're changing the target for PR? Because if they stay on this route, they're going to invite, what, 30,000 people this year through express entry if they keep up this pace, right?
Yeah.
They're supposed to be inviting, what, 110, 120, 130,000 people a year through express entry.
Right.
So what the heck is going on? Are they taking a break? Did the portal break again, right? Like in November where they paused draws, right? Because they added in postal codes, which is
Yeah. Yeah.
apparently a difficult thing to do technologically, but
Yeah.
whole other conversation.
So, oh,
So
sorry.
I'm just so confused. I don't know.
I could probably spend an hour alone talking about portal woes and technology and the development side of that. I'll leave that to the IT folks at IRCC, who I know they do work very hard. On our end, it becomes frustrating, but I do appreciate that there is likely some greater difficulties than we can imagine. But yeah, I mean, in today's draw, there was 730 people invited, which is just shockingly low. And if we look at historically what was done with express entry, I mean, right before the kind of general draws stopped and even the CEC draw stopped in 2022, the numbers were sitting in the 460s, 470s, 450s, right before the pandemic, even lower than that, 440s, 450s, all of which are meaningfully attainable for people who have a bit of skilled work experience in Canada. You do your program, you do your year of skilled work experience, you do good on your English language test. And then the deal was at that point then that there's a meaningful pathway to permanent residence for you. Now, I don't know where the policy shift is, where we're still absolutely taking in skilled workers through our, the global talent stream still exists. We still have a functioning temporary foreign worker program, a functioning international mobility program. But there seems to be this separation between the temporary foreign worker intake and then that transition to permanent residence. And, historically, we've always seen that for workers categorized as low skilled. I hate that terminology. I'm fine with maybe low wage workers, but we've seen that in that category of workers. But now it's this really kind of glaring lack of permanent residence options for most skilled workers in Canada. Like, I don't know that I would qualify. I don't think I would have enough time.
Yeah. Yeah, and in the last episode, I was chatting with an RCIC who came. She went through the entire process herself when,
Yeah.
in the heyday, she said, her clients were getting invites in the first year or two of express entry with like a 413, right?
Right.
Which now it was totally unheard of, right?
Exactly.
Good luck.
Yeah.
So I don't know, right? Like I said, one thing I would love to see from IRCC is just some level of transparency, right? Like what do you tell to a client now? We don't know what's going to happen, right? So
Yeah.
so and maybe we can segue this into, okay, what are some other options? But what do you tell a client right now who's maybe they've got a year left or 2 years left on their PGWP, or
Yeah.
I don't know, some other type of permit, and these express entry scores are crazy. Maybe what I'll ask is, number one, what do you think express entry is going to look like for the rest of this year?
Mhm.
Understanding that it's, you know, a bit of a guess, maybe more than a bit.
Yeah.
And number two, so what are some other recommendations that you might give to people to consider?
Yeah. So, I mean, if the rest of the year is anything like this month, then there's a very hard road ahead for everybody here, skilled workers, people with Canadian education, or not. And even, certainly into the applicants who aren't in Canada, there's going to be an uphill battle to fight. And so, making sure that you're aware of alternatives, and maybe this is where I can get into a little bit. I'm having conversations with my clients, and even now with the consultations that I do, the conversation I'm having about meaningful employer support is happening so much earlier than I think we absolutely needed to in previous years. I've always canvassed that with clients with consultations, but now having that conversation of, okay, your points are at 480, that's likely not going to be good enough, which just feels like a wild thing to say.
Yeah.
Is your employer willing to go down the LMIA route? Or can we, assess your eligibility for an LMIA exempt work permit through the International Mobility Program potentially? These are all conversations that we have to have sooner rather than later now. And because of course, if we are exploring alternate options, the LMIA, of course, that's an employer application. You need your employer support. And even for provincial nomination streams, you need your employer's support right from the get-go. I've had so many calls from clients saying, that my employer won't sign the form for, the OINP, which is the program I work primarily with. What can I do? And I mean, there's no positive obligation for employers to support under these programs, which leaves people in a real bind. I want to preface this that any conversation around the alternative options also aren't that great or that straightforward when we're navigating relationships between employees and employers.
Right. And that was going to be my next question, which is what's the average response, right? Both to, and maybe if you can preface that with explaining what the differences are between the two,
Yeah.
what would you say the quote unquote average response is from employers when they might, when your clients might suggest to them an LMIA or something like sponsoring them? I know it's not technically like a full on sponsorship, but
Right.
like, employer taking part or supporting in the PNP options as well.
Yeah. I mean, it's really so dependent on the employer. I've had employers where I thought for sure they were not going to be interested. Maybe they're a smaller company, or I just didn't get the sense that they were overly supportive. Say, yeah, let's talk more about what an LMIA looks like or what a provincial nomination program looks like. And then other employers where I thought it wouldn't be a problem at all. They're bigger companies, good, strong revenue streams, nothing to worry about there. They said, yeah, it's just not our policy to provide anything other than, your ongoing employment confirmation, which leaves people in the bind. And then I want to touch on the difference between the two. Of course, an LMIA can be used to leverage, additional points for having arranged employment in Canada, which is otherwise not available to folks who are on an open work permit. A lot of applicants will get tripped up on that as well. They think that the piece of paper saying you have a job offer in Canada is going to be sufficient for having a qualifying offer of arranged employment. Of course, that's not the case. So one way to help boost points by, at least 50, potentially 200 if you're working at the highest tier level, is to have an LMIA to support the job offer. If the company is unwilling to do that, if they're unwilling to go through recruitment, or if they're not eligible to go through the global talent stream, which gets rid of the recruitment requirement nicely, sometimes going down the provincial nomination route can be helpful too. And then those, of course, are provincial driven streams, the vast majority of which require an offer of full-time permanent employment in a province that in order to make use of those. But even the PNPs have been a little bit dicey, to be honest, over the last couple of years. Ontario's been quite unpredictable. It hasn't been a general employer job offer, foreign worker stream draw in over a year, 18 months now. It's all been occupation specific, really.
Oh, wow.
Yeah.
So the requirements from the company side are far less, as far as I understand, right, for the PNPs, in the sense that you don't have to go through the separate process of applying for an LMIA.
Yeah.
The employee can just apply right for the, Ontario stream that they apply for.
Yeah.
But what you're saying is they're not even really inviting the people who are applying through those employer specific streams?
I mean, I've had quite a few of my clients go through that stream, but it's probably more luck that their knock codes lined up with what Ontario is looking for. So
Right.
in that sense, yeah, as you know, Ontario's really been heavy on specific knock codes over the last year or two. So if you're in the knock codes that Ontario's drawing from, then that's great, and you'll be picked up. But if you're not, then you're going to be kind of in the same place as if you file an express entry profile. You'll submit your expression of interest to the province, and it will just sit there, and it won't be typed
Right.
up. So there's a waiting game there as well. And to be fair to employers on that front, the documentation could be just as onerous sometimes as what an LMIA would require, because there's, at least in Ontario, there's minimum revenue requirements, there's personnel requirements. So you're disclosing things like T4 summary statements and, Schedule 100s and 125s and, quite detailed information about the company. And some employers will bulk at that as well. So, and certainly the province has quite broad powers to come back and request a lot of documentation from the employer to confirm their eligibility.
Geez. So how do we see this playing out, Alex? Like it seems to me like, especially based on the ballooning of the international student space over the last 6, 7 years,
Yeah.
like we probably have more international students and graduates and temporary workers in Canada than ever before.
Yeah.
And PR, as we've just talked about, is getting harder than ever before. How do you think this plays out in the next year or two? Is it going to continue being super hard? Do you think they'll put in some more like TR to PR type pathways? Again, I know I'm asking, this is a tall task, right? I mean,
Yeah.
we're mostly doing a lot of guessing here. But do you have any thoughts, or, number one, what are your thoughts? And number two, any other advice, or, if there's aspiring immigrants, if there are some of these temporary residents that are listening right now,
Yeah.
obviously reach out and try to get some advice from you, but anything beyond that you can offer to them or mention?
Yeah. So, I mean, first, what this will look like, I don't see it getting easier. I think what we've seen progressively over the last couple of years is a real heightening of the bar, so to speak. The express entry points haven't dropped. Provincial nomination programs, yes, I guess their allocations have gone up in terms of numbers, which is great. But I don't know that necessarily means that there's going to be this ease that most applicants will find with those processes, especially since a lot of the streams require an employer. I mean, there's certainly streams that don't in Ontario and elsewhere, but again, 99% of the time we're thinking about an employer-driven stream. So I don't see it getting easier, which I don't love. It doesn't make my job easier. It doesn't make the clients that I represent's lives any easier to transition over. But I think coming into Canada with the expectation that traditional route of coming and studying and doing 1 year of work experience on your postgrad and going through CEC immediately afterwards, I just think that that's off the table now in a lot of ways, and having a little bit more strategy and in place. And maybe this is where some of the caps that have been put in place around students is aimed at aligning more closely with what's happening on the permanent resident side. If we have people coming here, graduating from master's and doctoral programs, perhaps, I mean, certainly their points will be higher in express entry, given the level of study that they're doing. Perhaps the skilled work experience that they'll get will set them up, to perform better in these economic immigration policies. But for people who are kind of caught in the middle or caught in between when these caps came in place and have already been studying here, there's going to be a real hurdle for them to overcome. And I think having these conversations with employers earlier on is going to be the best bet. Thinking very carefully about which occupation code you go into after you graduate. I think we will see the continuation of these category-based selections. I don't know what was going on this month, not drawing from them. I anticipate we'll see the return of those over the year. I mean, again, could be completely wrong, but I don't think that they'll do away with those. So again, if you can, honestly say that you fall into one of those knocks, I don't, it's to your benefit to be associated with them. So,
Mhm.
but again, this is all conversations you need to have in the context of an employment relationship as well.
For sure. Yeah, I mean, I think one problem that we've seen play out is when there's no alignment between PR targets and temporary residence, it's
Yeah.
just going to create a mess, which it
Yeah.
has.
Oh, yeah.
And like you said, I think the next 1 to 2 years are going to be very ugly in the sense that there's probably going to be a lot of temporary residents that are going to lose status, and
Now,
God knows, what'll happen as a result of that. Can you give some advice? So let's say I'm a temporary resident and I've come to the realization, as probably most have, that, like you said, the regular smooth pathway to PR isn't going to work.
yeah.
What are some pieces of advice you would give to these people in how they can approach the conversation with their employers, right? Because this can be a very difficult and, personal and stressful time and conversation. And probably some employers are maybe more open minded than others. But do you have any advice to employees of like how they could even approach those conversations to give themselves the best chance at success?
Yeah, I mean, I think you certainly not being an employment or labor lawyer, although there was a really great professional development recently that Ontario did, the OBA did around the intersection of employment law and immigration law, and the evolving kind of interpretation of human rights legislation in Ontario and the requirement of employers to support existing temporary foreign workers that they have in their permanent residence applications. So I think,
Hmm.
in the future, we might see this evolution of how human rights legislation gets interpreted in this immigration context as well. And I would certainly be very interested to keep an eye on the evolution of that case law. But as of today, of course, there is no legal requirement or positive legal requirement for employers to support. So going into these conversations, I think having a clear understanding of what the process looks like. Some employers I know have balked at a process just because they don't know what's involved. Seeing if you can get in through the global talent stream, which avoids a recruitment component, which again can be very burdensome, I suppose, or perceived as being very burdensome for employers, can be one way of doing this. Looking at LMIAs that are just used to support permanent residents, these express entry LMIAs, so to speak, which are exempt from that $1,000 processing fee for companies where a budget is a big concern to them, then that could be another way to approach that. And yeah, I think going in with all of the information exactly about the process and the timelines and how it will actually benefit an immigration application and standing in express entry. I mean, the difference between 50 points and not having 50 points for a lot of people, if they're sitting, in the 460s, 470s, which are a lot of folks are, could make the difference between being selected or not. Although I guess with this month, all of the draws being above 540, that might not be the case. Maybe it'll make a difference for people in the 490s and 500s moving forward.
Yeah, no, that's great advice. And as someone who did plenty of LMIAs back in my day and plenty of, hey, can you help me convince my employer that it's worth it to do an LMIA? Like you said, half the battle, if not more, is usually just on the education side, right?
Yeah.
Educating employers of what it entails and hopefully convincing them that it's not as daunting as immigration typically does seem to most people. Timelines being another factor,
Oh
right?
God.
But also maybe highlighting how, especially if you know that your employer values you and maybe they don't appreciate, like, hey, listen, my permit's expiring in 7 months. If I don't do anything about it, I might have to leave, right? So
Yeah.
maybe they don't appreciate the severity of the situation.
Yeah.
I wanted to ask, oh, yeah, go ahead.
And just to add to that, I'm thinking about conversations that I'm having with my clients now. We really are, I'm always thinking of ways that I can make my services more helpful. Doing a consultation where we just talk about express entry or just talk about PNPs and, having services priced out individually for that. I think that makes less and less sense. So I think as a profession, and I've certainly seen these conversations, amongst colleagues at my firm and elsewhere about how can we set up services so that they're, cost effective and really respond to the needs of clients. I don't know. I mean, people need eligibility assessments for express entry generally, but having that conversation from day one about, okay, let's assess eligibility for express entry. Let's talk about provincial nomination programs. Let's talk about LMIAs, processing times, fees, all of that so that you're well prepared to make your plan for the next year or two. It is more realistically the type of conversation that I'm having now versus, okay, you contacted me, you want to talk about express entry. I'll tell you about the Canadian experience class and then you can go on your way. I think there's now,
Right.
I think it's on us as well too, to really draw attention. I mean, most of the consults I have, they know it. There's kind of a sense of panic in a lot of people that I'm speaking with, but for people who don't understand, the severity of what the situation is for transitioning to permanent residence, I think having that conversation as early as possible and really doing a full assessment of here are your options for permanent residence LMIAs, and let's make a plan for you before your current permit comes up.
For sure. Yeah, more important than ever. Alex, what would you, if you were Minister Miller right now, let's say you get thrown into office today and you have a month, what would you do? What do you think are some of the biggest issues?
Yes.
Loaded question. What
Oh
do you think
God.
is, some of the loaded, biggest issues that we're seeing right now with Canadian immigration? And maybe what are two or three of the first things that you would do to try and change or improve the system?
Yeah, that's a really great question. It's a tricky one because on my end of things, I see this real need for a better sense of transparency. That we're in this era of opacity with IRCC that I don't really remember being in place when I first started as a lawyer, and certainly when I was working within IRCC. So having ways for more meaningful and open communication, I would try and find a way to do that because right now, there's not a good way to get in touch with a human at IRCC, and it's the real detriment to our clients to not be able to find out what's going on with an application, or when an error is made, if you attempt a reconsideration request, heaven forbid, it's going to take months to hear back. Programs are being announced, and the eligibility for those programs are being provided the same day the program opens. I'm thinking here of the reunification program for Haitians, Venezuelans, and Colombians, of course. Like that, it's the cap on international students being announced and requiring an attestation letter the same day. I would try, if I was put in that place, to not do these massive policy shifts or the creation of new programs without any warning. And in my mind, that's linked to this need for some accessibility and transparency in how applications are being processed and how programs are being administered. And that might go a little way in helping people calm down. In terms of actually
Absolutely.
addressing what we're talking about, you know, there's I've had a long-standing issue, and I don't know if this would be helpful in the short term, but I've had a long-standing issue with our refusal to facilitate meaningful permanent residence for people who come here in quote unquote low-skilled occupations. I'm going to include the seasonal agricultural workers program in that, as well as the people who come here on low-wage LMIA-based work permits. They come, they do this hard work in Canada, and there's not a great or really any pathway for permanent residence outside of a few provincial nomination streams where they'll draw from like the tier 4 and tier 5 occupation codes. So as much as I would hate to add a program right now, given how complex immigration processing is, I I would be remiss if I don't think if my platform as minister didn't include some recognition of the need to stop this kind of revolving door of low wage or low skilled workers in Canada as well. So I would start there and these category. I don't know for getting the high skilled workers back into a meaningful place. I don't know if we can continue having these really high, 546, 542 draws with express entry. We have to find a way to make the points a little bit more accessible again, to
Right.
give people a meaningful shot at staying here.
Well, the points really comes from volume, right?
Yeah,
Like what I find a common misconception is like, well, why don't they bring the score down? And in reality, they don't pick a score, right? They actually pick the number of
right,
people they want to invite in a draw, and then they look at the last person's score, and that's what ends up being the score.
right.
So the problem so far has been, again, as I look over, 3 draws so far in 2024 as of January, right? Keep in mind this was recorded on the last day of January. 1,500, 1,000, 730 people invited. So something's going on,
Yeah.
right? You have
Mhm.
to imagine they'll go back to doing bigger draws. Until then, as you alluded to, not much transparency. The problem is like, and I remember like pre-COVID very clearly, back in
Yeah.
the glory days, as I like to call them,
Fair enough.
is when Express Entry, yeah, was like it was always all program draws and it happened every 2 weeks.
Yeah.
And you could kind of, you knew, right? You had to talk with someone. Oh, you have a 470? Okay, yeah, it looks great. Oh, you have a 440? Okay, we might want to do like this, and this to kind of get you up to here, right? And
Yeah.
so you almost didn't need as much transparency from the mouth of IRCC because their actions were pretty consistent.
Right.
And now it's just a total flip, right? Like you look at the last 12 months of express entry draws. Oh my God, like my mind is spinning.
Yeah.
And as professionals, we can't even make sense of it, right? So I don't know. I just hope they can get back to some I would love more transparency,
Yeah.
exactly as you said. I just have a feeling we won't get as much of it as we want. But hopefully we get some consistency so at least you and I can look at these numbers and try to make some sense of them looking forward for our clients. The last thing I wanted to ask you about too, Alex, is so what was it like doing the processing, right? Like I can't let you off the show without asking a little bit about this, right? Because
Yeah.
we've all heard the stories, right? Oh, the processing agents have 4 minutes and they have to process like 100 a day and this, that, and the other. Like,
Yeah.
I don't know how much you can or can't share, but can you share a little bit about what your experience was processing those applications back in the day?
Yeah. So I think my experience, I started in 2010. I was a case processing agent working the evening shift. So I worked from 4 p.m. till 10 p.m. down at the processing center here in Ottawa. And this was before the time of, any of the AI, if you want to call it, or predictive algorithms or supported decision making. So it was really left up to us individually. I mean, we had our own computer processing software, and we certainly migrated over to GCMS fully while I was there. I started when FOSS was still the processing system, if you can believe it. And this is kind of getting into more the nerdy immigration stuff, I suppose. But so yeah, we were left to individually process applications, and there wasn't this kind of pre-assessment of the level of risk or the level of complexity. Things weren't sorted into batches of applications. Really, the only groupings were people who applied as family members. And I did have a quota, and that did change based on the line of business that I was working on at any given point. Certainly I was there when off-campus work permits were still needed in addition to a study permit to be authorized to work. And I would be, expected to do around 150 of those in a shift. So it's a high
In a
number.
day,
Yeah, yeah. And
150, Jesus.
yeah. And similar numbers for post-grad work permits, a little bit less because there was some complexity on those. And I did more complicated work permits as I, got more senior there as well. So it was a really fast-paced operations environment. And, I can only imagine what it's like now with the advent of different technologies that are used and are developed to help support these decision making. I can't imagine what the pressure must be like to meet certain quotas, and with the looming backlogs. I remember when I was there and we worked on reporting, it was considered, the end of the world if there was a backlog of like 15 days on an in Canada work permit application.
Oh boy.
Now
Yeah,
it's
I
like
can only
it's
imagine.
6. It was
Yeah,
50 for a long time longer. I think when I checked, yeah, today it was sitting out just over 100 days. So yeah, I have a lot of empathy for the officers, and the case processing agents who are doing these decisions. It's not easy, and there was a lot of pressure, anyways, when I was there in terms of quotas, and
I
the
bet.
ability to use your discretion might be less. I don't know this. I would just get the sense that if there's this kind of suggested decision that you should make, or a suggestion that something is more complex put in front of you, that could impact the ultimate decision you would make. But I know when I was there as an agent, we had such broad abilities to request missing documents, and things weren't automatically returned as incomplete. And it's gotten so punishing now almost. If something is missed, and I have clients come to me and they missed the smallest thing that could have been requested, and instead their whole express entry application is returned as incomplete. They need a new profile in the pool. It's really just unforgiving. I think that's more the word I want to go with now. It's become increasingly an unforgiving area of law to practice in this corporate immigration, economic immigration world.
For sure. And can you talk about, maybe generally speaking, what were some of the like maybe prospective immigrants that are out there, preparing applications on their own? What would you say were the most common mistakes that you found, or most common reasons for refusal that like maybe could have been easily avoided, right? For
Yeah,
a
no.
prospective immigrant.
there seems to be a lot of issues around when so I'm going to think here in the context of express entry applications, when people are doing, their full application for permanent residence, having the right police certificate seems to be a real issue for a lot of people. IRCC's instructions on obtaining police certificates are not always the greatest. Getting the right police certificate, depending on what country you're dealing with, can be very difficult to do. So just making sure that you're double checking IRCC's instructions on what exact police certificate they want. I see this a lot with Australian applications, some Korean applications, some Philippine applications too, actually, depending on what it says on there. There was I had a client recently, it was an Indian national, and there was an issue with how far the police clearance went back. It was tied to the recent address. It only went back 7 years. They wanted it for the entire time they, of course, had resided in India. And the whole application was returned as incomplete. And it can really throw a wrench in the plan. So just, making sure that I would say, yeah, police clearances seem to be a really big one. Just double checking the instructions on those. Employment reference letters for previous work experience, either in Canada or outside of Canada. I can see there's a real issue sometimes in getting supporting documentation for that. So really just trying to put together the strongest case possible. Of course, best evidence being letterhead signed recent employment confirmation letter, but barring that, previous tax documents, previous employment contracts, other reference letters. Oh, and on that note, making sure your LinkedIn profile, if you have it, matches whatever you put on your resume. Officers
Really?
officers create people on social media. I totally did when I was working at IRCC. I create most of my clients. They know that I do. I want to make sure that what they're saying on their LinkedIn matches up. Their resume matches up with what I've said in my submissions, matches up with what the employer said about their experience. So yeah, officers can and do use third-party social media as well to look at what you said about yourself in the context of your application.
Wow, that's a great piece of information and super interesting. So thank you for sharing. My last question is, did you read the cover letters that were submitted by if there was a representative? I have to know.
I
I have to
did.
know. Yeah.
I did.
Did others?
I'm I would hope that they did. I don't think everybody read them as thoroughly as I did, but I've always just been a hopeless law nerd, hence, why I went to law school, I think. But I totally did. And when you see a lot of submissions from the same lawyer or firm and they're good, strong submissions over the years, maybe it matters less now building that relationship, so to speak. But I think that there's still an importance of making sure that the quality of the work associated with your name and with your firm name is to the highest standard possible. Because certainly when I was there, I wouldn't ever overlook eligibility requirements or documentary requirements. But when you see the kind of same consistent high level of quality in the applications, there is an element of trust there. And I know I've really taken that to heart over the years that I've been in practice, is that it matters what's being said with my name attached to it. And I think that there's an obligation to ensure that the best quality work that you can do goes out. So yes, I did read the submissions, but I'm not going to pretend that everybody was as much of as a nerd about it as well. But I would still say it still matters what the submission say in terms of, maybe like future litigation if you need to, or, just knowing that you did the best possible, kind of relentless advocacy work for our clients.
Right. No, that's great to hear. And for those who may not be as obliged, most immigration consultants and lawyers will include a cover letter or submission letter, kind of explaining maybe just the basics or any, additional information that they want the processing agent to be aware of.
Yeah.
And I've had many a conversation with people to try to determine if processing agents even look at them, right, or read them. There's some firms that have told me they'll write a 5, 10, 15-page cover letter. My stance was always I wrote one, but I kept it pretty short. I like to keep them anywhere from like 1 to 3 pages max, because I figured with your quota, there's no way you're reading a 10-page cover letter, right? Maybe you're scanning the headlines and, reading the important stuff. But anyways, what it does sound like is having a crisp, well-written cover letter. Well, let me ask you this. Having a crisp, well-written cover letter from a ideally, reputable lawyer, consultant, and or firm probably won't hurt your case, right, when it's in front of a processing agent.
No, I don't think it will hurt your case. And, having for me on that front page, having all of kind of the tombstone data for the client, and then basic, information about the NOP code and job title, all of the easy, especially when I'm thinking about work permit applications, maybe less so. I mean, I still do it for the permanent residence applications, but certainly when putting together a work permit application, especially if they're going to the port of entry to apply, having everything on the front page that the officer will need to understand the application is important. And I'm inclined to agree with you. I don't think we need, 10, 15 pages. For more complex applications, my submissions will go up into 5 or 6 pages, but I do try and keep them short because, I'm under no illusion that everybody's going to sit there and read cover letters the same way I might have done when I'm processing.
For sure. Awesome. This has been really great, Alex. Very eye-opening, both on the PR, and kind of what's going on right now front, and the what might go on behind the scenes, which is always super interesting for the immigration nerds out there. If anybody does want to get in touch, maybe learn more about you or learn more about the firm, where do you recommend that they go?
Right. So I'm an associate at Mann and Sandaluk. Our firm website is migrationlaw.com, and you can get in touch with me directly there, or through our wonderful client care team who'd be happy to chat further about talking with me or anyone else at the firm. I'm also on social media. I'm on LinkedIn. I'm on Twitter, or X, as I suppose I should be calling it now. So I'm searchable by name there. There's a lot of people with my last name floating around doing immigration law. So always happy to connect there as well.
Awesome. And we'll have links to those, the website and some of the socials in the description, whether you're watching on YouTube or listening on the podcast platform of your choice. Alex, thank you again for coming on the show. Really appreciate it.
Awesome. Thanks so much for having me. This is great.